SJC-11627, Commonwealth versus Alex Scesny.
Good morning.
Good morning, but why don't you give us a moment before we can start? All right. Now, good morning.
Now, good morning. Chief Justice Gantz, members of the court, my name is Ken Seeger. I represent the defendant, Alex Scesny. Your Honors, I would like to begin by discussing the sufficiency of the evidence to convict Mr. Scesny of the crimes of first-degree murder and aggravated rape. Your Honors, under the standard set forth in Commonwealth versus Lattimore, the evidence in this case, in a light most favorable to the Commonwealth, was insufficient to permit a rational trier of fact to conclude, beyond a reasonable doubt, that Mr. Scesny committed these crimes. And I would like to first point out that the Commonwealth's case was based entirely on forensic evidence. It did not contain any supporting incriminating circumstantial evidence such as consciousness of guilt, motive, statements, admissions, and so on that we see in many other cases. This case was based on the forensic evidence. It was based on a DNA hit. And at trial, Mr. Scesny did not dispute that he had intercourse with the victim and that his DNA was found in the victim. And he acknowledged that at trial. The Commonwealth's case was based not only on that, but on the presence of stains that were located on the victim's body. And those stains, Your Honor, it's very important to recognize, all contained mixtures of two persons.
Do you dispute that they were blood stains?
I do not dispute that they were blood stains. We're talking about three stains, two of them screened positive for the presence of blood, one of them confirmed positive for the presence of blood. I do not dispute that they were blood, even if we assume that the two stains that screened positive, if we just infer that they contain blood, the problem is whose blood? Because these stains, each one of them contained a mixture of two persons. And that's very significant. And the reason it's important is because
I thought you were disputing that it may not have contained blood from the defendant.
correct.
There may have been blood from somebody else, but there may not, the source of the DNA from the defendant may not have come from blood.
That is correct.
So you are disputing,
Well,
at least in a sophisticated way, that the stains were blood.
Right.
Because that was an important part of the Commonwealth's argument.
I'm not disputing these stains. One of them confirmed positive for blood.
Somebody's blood.
Somebody's blood. The two others screened positive for the presence of blood. Somebody's blood. Did not confirm, but screened. But okay. But whose blood? And it's very significant because the Commonwealth in this case argued at trial and on appeal that it was the defendant's blood. And it was the Commonwealth's theory at trial that the defendant, after his encounter with the victim, beat her up, punched her in the face, broke her teeth, bled on her, and that is his blood. And this is the Commonwealth's theory of the case.
Could you remind me who was excluded from those samples?
Well, there were three samples.
Was the victim, was she included in the possibility of who was there?
It was insufficient. I can go through each one, each stain. The two other suspects were excluded from those stains.
Yeah, that's really where I'm going. Both of them were.
They were.
Yeah.
Yes, they were. And the results were insufficient to include or exclude the victim in the case. And I should also point out, Your Honor, that there were stains found in the victim's underwear, and the statistical probability of the defendant being the contributor of one of those stains.
That 1 in 61, is that the one?
No, the 1 in 61 pertains to two of the stains. Okay, so one of the stains is 1 in 1 billion. Two of them are 1 in 61. The stains on the knee and the sneaker. The stain in the underwear is half, so half the male, Caucasian population.
Well, there was also a stain on the hip where his DNA was essentially a match.
The stain on the hip was 1 in 1 billion.
Yeah.
Was 1 in 1 billion. The stain in the underwear, and I've tried to detail this as well as I could in the brief, was half the male population, Caucasian population. But, and it's undisputed, there was definitely the DNA left by an unidentified man in the victim's underwear.
But was there also some DNA from the defendant, or theoretically, 1 in 61 from the defendant?
The 1 in 61, maybe I should just go through it. So there's a stain on the hip, and that's 1 in 1 billion. The stain on the knee is 1 in 61. The stain on the sneaker is 1 in 61. Okay. The stain in the underwear is half.
1 in 2.
1 in 2. Half the male, exactly.
That's
half the
the
male
YSTR or STRY? I mean, that's the
yes.
male chromosome.
Yes,
thing.
the male chromosome. And there's another, absolutely another male chromosome. It's been unidentified that was found in a stain in the victim's underwear.
But isn't the crux of your argument the criminologist's testimony was admitted because that was it was the drainage evidence that put your client's DNA. I think she said that it would have drained because it did not drain out on her underwear.
It is so the crux of the Commonwealth's case is that it's the absence of drainage that incriminates the defendant. I should point out...
And without that testimony, I understood your brief to say they could not get a conviction, and it was improperly admitted.
It was improperly admitted, and I should point out it's another related argument in this brief that that testimony was improperly admitted. And I should point out that it was the pathologist, Dr. Henry Niels, who tested...
Yeah, but if the criminologist's testimony was properly admitted, you lose, don't you?
Well, I don't think I lose, Your Honor. I mean, this case is about the piling on of inferences. So this
It's a pretty good inference.
This testimony requires the jury to pile on inferences and conclude that there wasn't drainage, even though you have witnesses who say there may not be drainage. There wasn't drainage. She did not pull up her underwear. There was no drainage, and the absence of that shows that he must be the perpetrator. So this is about the piling on of inferences. And I suggest it's very important in this case that the second issue raised in the defendant's brief is that the criminologist was not qualified to render that opinion. The only pathologist, the only person with a medical degree in this case who testified that it might not happen. It doesn't necessarily happen. And Deborah McKillop was the criminologist, and she's a qualified chemist, and she did not testify regarding how many cases such as this she might have seen. There's no testimony regarding that.
But do you have to go to medical school to say that the sphincter muscle may or may not have kept all the fluid in the victim's body?
It's an opinion that I would suggest needs to be rendered by...
Could a physiologist?
But a physiologist, a doctor who's been to medical school.
Well, you had the upper hand here because you had a physician testifying that it may or may not happen, and you have somebody, according to your theory, who isn't qualified testifying to that. So that was not so much of a problem for you because you had the medical person agreeing with your theory of the case.
That's correct. But it is an important part of the Commonwealth's case, this issue regarding the drainage.
Couldn't you cross-examine on that, on her qualifications?
I don't believe there was very much cross-examination into that.
No, but it could have been done.
Certainly that could have been done.
And this is very much a matter of the judge's discretion, whether to admit the testimony.
It is a matter of discretion. And I I argued in the brief that it's an abuse of discretion to permit that testimony.
Wasn't the, maybe not the only thrust, but it seemed to me that a significant part of her testimony was based on her experience of having been at crime scenes and done these kinds of forensic examinations, and that's usually what's there or not there.
Well, she was experienced, and I won't deny she'd been a chemist for, I believe, 11 years. She was not qualified to make this particular, to render this particular opinion.
She could
Well,
testify to
everybody
her
understands
experience.
Gravity, right? I mean, gravity is, what, do they teach that in 6th grade science, 7th grade science?
Well,
So that's what we're talking about
that's
here.
true. I mean, anyone can testify about gravity. But I would suggest that only the physician could testify to that function of the human body. And he, in fact, and I just asked the court to just recognize that he, in fact, testified that it might not happen.
But isn't it common in cases of this nature, where this issue comes up, that there has been drainage onto underwear? Isn't that? I mean, and couldn't the criminologists have testified? Yeah, I've had many cases, maybe hundreds of cases. I don't know, something that could have come out in cross-examination. This is a common occurrence.
The problem is, Your Honor, this is just this issue about the drainage. It just requires the jury. They had to speculate about this. They had to pile inference upon inference, and they had to speculate that there wasn't drainage. She did not pull up her pants. He must have been the last person to be with her. This evidence presents alternate propositions. There was evidence of another person who evidently there was drainage, and that person has never been identified. I just put it out there.
Could I shift your focus to the prosecutor's closing argument?
I would like to get to that.
There was no objection to it?
There were some objections to what I've argued, and there were no objections to
There
other
was a
areas.
curative instruction to this stuff about, I won't even call it evidence, kind of.
Right. But here's the problem. There was a curative instruction, and I would suggest that, and I've detailed the entire argument, the comments were too pervasive to be cured by that curative instruction. And the point that I tried to make in the brief, Your Honor, is that this defendant, he had every right to bring this third-party culprit evidence. That we know. This evidence was properly introduced. It was subject to a motion in limine. It was admitted, it was argued, and he presented this evidence. He had every right to do so. And I would also just further suggest that some of the evidence, it was up to the jury, obviously, to decide whether or not there was sufficient evidence to point to these other suspects.
Well, was there also an argument that the evidence was improperly admitted? It should not have been admitted?
Well, I believe the Commonwealth did object to that evidence at trial, but it was admitted over the Commonwealth's objection.
Yeah.
So it was properly admitted by the trial judge.
In part of the closing argument, the prosecutor's closing argument was that it should not have been admitted, I thought.
He said you should not have. He said
You shouldn't
he
even
really
call
went
it
beyond the
evidence.
bounds of what he should say. I mean, it was very pervasive. I mean, calling it fiction, the stuff of good books, immaterial, irrelevant. You should never have heard it. It's a bowl of spaghetti thrown against the wall. This goes beyond what a prosecutor should argue. And some of
And
this
that it was designed to distract and confuse you.
This was just designed to distract and confuse the jury. And some of this evidence, Your Honor, of course, as I said, it's up to the jury it's up to the fact finder to decide whether or not there was credibility there. But some of this is, I would suggest, is quite incriminating. I mean, the victim in this case made a very cryptic and mysterious statement on the last night that she was alive about her ex-husband. In fact, she said, no, the very last night that she was seen, she said, she was talking about this dispute with her ex-husband who had a history of abusing her. And she said to her friend, one of us will be alive tomorrow and one of us won't. It's very foreboding thing for someone to say in the last night of their lives.
But the evidence pretty clearly excluded him from any involvement, though, right?
The forensic evidence did, in fact, exclude him. But again, there was, again, as I've tried to detail in the brief, these stains, all of the stains, contain mixtures. And some of the mixtures simply, some of the stains in the mixtures simply could not be determined who the other person was.
So what effect do you think the closing argument had on the jury's consideration of the case?
I would suggest it was very significant because it's went right to the issues. This is not some collateral issue. Went right to the core of the case. I mean, the core of the defendant's case was identification. It wasn't me. It was perhaps one of these other people who had a motive. The Commonwealth in this case, as I stated earlier, didn't present any further incriminating circumstantial evidence, motive, consciousness of guilt, and so on.
Do you have any problem with what the judge did to address the counsel's issues with the closing?
I have an issue. There was a curative instruction that I would suggest was just couldn't balance out the pervasiveness of these improprieties. If these comments were just a one-off comments, maybe it could be let go. But this pervaded the Commonwealth's closing argument. This went beyond the bounds. So that one curative instruction just wasn't sufficient to cure the problem.
It's a pretty forceful curative instruction, as curative instructions go. Don't you agree?
Well, she said the evidence that you were told you should not consider.
I don't usually do this, but I'm going to do it now because I need to.
Well, again, I mean, I would say that these closing argument improprieties, they were pervasive. They went right to the core of the issues in the case. It wasn't some collateral issue that really the jury just didn't need to discuss and deliberate over. This was very important to the defendant. This was the entire defense that was just trashed in a very improper way. This is not the kind of comment that should be disregarded. Bowls of spaghetti hurled against the wall. This is properly introduced evidence that he had every right to introduce.
If I could ask you about some parts of the evidence, you say that there was a concession that he had had sex with her. Was that through a statement, through the opening statement or closing argument, or did he testify?
He did not testify. It was in closing argument. So
there was no.
The defense counsel's theory in closing was, I mean, the statistical probability of the DNA that was extracted from the victim was 1 in 13 quadrillion.
Okay, so that was a concession by
That's from the
counsel.
vagina?
No, that's the.
I mean, from the rectum? From the rectum?
Yes.
And was there any evidence as to the location of the killing? I gather there was some expectation that the killing occurred where her body was found as opposed to having been dropped there, but was there any evidence as to that?
I believe the Commonwealth's theory was that she had been taken there and thrown out by the side of the road.
So the evidence was, at least as the Commonwealth presented it, that the killing did not occur at that location.
That was the Commonwealth's theory.
Was there a lividity issue that supported that?
There was lividity to the victim, Your Honor.
And was it consistent with the position that she was found in, or inconsistent with it?
I am fairly certain that it was consistent with the position in which she was found.
So she was thrown out of the car when she was alive?
Yeah, I'm not certain. I don't believe there's any testimony to that effect that may be true.
This is a factual question, but there is in the briefs a discussion about the blood, or maybe it's the examination at trial, about the blood, and if she'd gotten up or something, it would have smeared the blood on her body. And so if she did it come up that if she was actually moved there, that wouldn't have affected the blood, whether it would be smeared? Yeah, am I being clear? Not very.
Yes, you are, Your Honor. I'm not certain exactly how much testimony it was regarding that question, Your Honors. It was part of the Commonwealth's theory that if she had gotten up and pulled her pants up, then the stains would have smeared. These are minuscule stains.
Yeah,
She described them as being a little bit larger than a period. So to suggest that they would not have smeared, this just goes to further show that this case is about the piling on of inferences without sufficient proof.
All right, thank you.
Well, thank you very much, Your Honors.
Good morning. Ellen Lazar-Moore for the Commonwealth. The evidence and the reasonable inferences from the evidence sustain the defendant's convictions of murder and aggravated rape. The evidence showed that the victim was found lying face down on the ground with her pants and her underwear pulled down. The defendant's sperm were found in the victim's rectum, and what the jury could have inferred was the defendant's blood was found on her hip.
Now, could you just answer the question about what the Commonwealth's theory was about where this all took place, if she was dumped by the side of the road?
Yes, it wasn't clear, but the prosecutor did argue in closing that the killing could have occurred about half a mile away. There was a farm. There was testimony that there was a farm where a lot of prostitutes took their so-called johns, and that because there didn't appear to be evidence of a struggle at the place where her body was found, it's possible she was killed half a mile away and then brought there. But
the government wouldn't have smeared the blood stains?
So the evidence about the smearing of the bloodstains had more to do with if her pants had been pulled up.
Clothing, the effect of the clothing.
Yes. So along with the argument that because the defendant's sperm was in her rectum but not in her underwear, that suggested that she had not pulled up her underwear after intercourse. There was also an argument that because the bloodstains on her body were neither smeared nor dislodged, she had never pulled up her underwear or her pants.
But yet, if the body were moved, there would have been no disruption?
There wasn't any testimony. There was no
There
questioning
wouldn't have been
about
any
that.
discharge if the body was moved?
Of the sperm.
Well, of the drainage.
The
That's the word
drainage.
I'm looking for. Drainage.
Yeah.
Yeah.
So again, there was no testimony about that. The lividity of the body did suggest that she was found in the position in which she had been killed. And so whether...
So does that mean that the person who killed her moved her and put her in the same position where she died, and then when he relocated her body, put her in exactly the same position?
And we really don't know. I mean, it was one theory that it might have happened half a mile away and then the body was placed there, but it's really unclear. What is clear is that she is found face down with her pants and underwear pulled down. The defendant's sperm is in her rectum. The evidence suggested that her underwear were never pulled up after the time that she had intercourse with the defendant.
Was there anything, the defendant had a truck, a black truck, is that right?
I don't believe evidence of the defendant's truck did come into evidence. There was evidence that someone in a black truck had given the victim a ride that night, but...
So no evidence that the defendant's truck was used to transport the body?
No. There was nothing, I don't believe there was anything about what the defendant drove at that time, and certainly there was nothing about the defendant having a truck that drove the victim. Because this crime happened in 1996, and he wasn't identified until more than 10 years later.
The witness who said I guess it was the bartender,
Yes.
who said she'd seen the defendant at the same bar that the victim was at. Was that on the night of the murder or just sometime?
At some time. So the killing happened in 1996. In 2008, after the DNA matched to the defendant, they go back and talk to the bartender, and they say, around the time that this happened in 1996, do you recognize any of these photographs as depicting somebody who used to frequent the bar? And she identifies the defendant's photograph, but she says that 4 out of the 6 looked like people who used to frequent the bar. That was the extent of that testimony. And so it did come out that 4 of those people looked familiar to her, and it was around that time. But she didn't specifically say, I saw him there on that night.
But
There was
the
no
question was,
suggestion
the
of
question
that.
that was posed was essentially asking, I take it from what you just said, asking for information from the past, not 2 or 3 years ago.
Right. No, it was, do you recognize him as having been a patron in the bar around that time, but not specifically on the night of the murder?
With regard to the ligature, no ligature found, I assume.
No.
Any indication of what the ligature was made of?
No.
Any evidence as to what Mr. Scesny's employment was or what he did for a living?
I don't believe so, not that I recall.
Any evidence about him at all, apart from the fact that that during this time period he was in that same bar that she hung out in?
No, other than, well, strong forensic evidence tying him to the victim. So obviously he conceded that he had intercourse with her, which frankly he had to do because of the evidence of his sperm in her rectum. The condition of her body also suggested that the killing happened at the same time as the sex.
Okay.
She's lying there unclothed, she's beaten, her teeth are broken, she has bruising on her face, and then there are drops of what is arguably his blood on her body. And then again, the evidence suggesting that she never pulled up her underwear or pants after the time that the defendant had intercourse with her.
Any indication that the intercourse was anything other than consensual?
Yes, all the things that I just mentioned.
But there was nothing to indicate that the intercourse was forced.
Didn't start consensually anyway.
Well, there was no injury to the genitals or the anus, if that's what you're asking. The medical examiner did say that. However,
The other things could have simply been after the sex. I mean, there's nothing that suggests that the sex itself didn't start out consensually. If she was somebody who was in the business.
yes, there was evidence that she had been a prostitute. But, Your Honor, this court has recognized in other cases that I cite in my brief, Charamond and Gaynor and Waters, that injuries to a victim who found dead and evidence that the victim had had sex at that same time can suggest that the sexual intercourse and the sex happened essentially simultaneously and that the sex was not consensual.
Was there any evidence at the trial about what happened in the interim between 1996 and when the defendant was identified in the case? How did that come about?
No, the only way the evidence came in was that it just said that in 2008, the defendant's DNA was entered into the database, and there was a
Was that
so-called
a
hit.
CODIS hit?
Yes. I mean, I know that he had been convicted of another crime, but that did not come out
Understand.
at trial. But that's the way that it happened.
Did there, was her purse found, or did she have a purse or a wallet or something like that?
No, she was identified through fingerprints.
And in terms of her being a prostitute, what was the evidence as to that? When had she been a prostitute? During this time period?
So the only evidence as to that was somewhat disputed by her daughter. Her daughter said, we spent the day together, and around 9:30 or 10 that night, she said she was going to, I believe it was called Work-A-Day, which was a temp agency. The defendant cross-examined her and then impeached her with a statement that she had made to a trooper at the time of the crime, where she evidently had said to the trooper that she had known that her mother had been a prostitute at times and that it's very possible that when she went out that night saying she was going to go make some money, that what she meant was through prostitution. And the trooper testified that it was his understanding that he understood the daughter's statement to mean that the mother was going out to prostitute herself.
And we know that she didn't have money earlier in the day, and that when she was in the bar that night, she did.
So the daughter testified she thought her mother had $2 when she left, and then the bartender testified that when she went to the bar, she paid for her drink with a $10 bill. Although the timing isn't exactly right, because the bartender said that she was there, I believe, between 7 and 8 o'clock, whereas the daughter said it was after 9 when she went out and then was not seen again. But that was the extent of the information about prostitution.
And when she went out, did she drive, or when she left?
No, she left on foot.
She left on foot
Yes.
in Fitchburg.
Yes. Well, I should say she left. The daughter said she didn't know if anyone had picked her up. She wasn't aware of anyone having picked her up. She did say that earlier that night her mother had been given a ride home from the store by a person in a black truck. She didn't know when her mother went out later whether that black truck was still there, and she wasn't able to see the face of the person when her mother was dropped off earlier. But the mother didn't drive herself. The victim did not drive herself, we know that.
And on her person, any money found?
Nothing that was reflected in the record. Was the red and white truck, was there some evidence about its being somewhere around in this vicinity that night?
So there was evidence about 2 different red trucks. One was James Weber's, who was her former husband. And then there was another truck that was owned by Everett Carlson, who was another person who the defendant argued could have committed the crime. There was testimony from a man who owned a market or liquor store in Fitchburg that he saw the victim getting into a red truck alone. I think that was around 6 p.m.
What does that mean, alone?
He said in his
was nobody
testimony
else in
she
the
got
truck?
into the truck alone, so he didn't see anyone else with her. He did say that he knew that it was not James Weber's truck, because he knew that James Weber's truck, I believe, was a Dodge and this was a Ford. He also said later that he didn't think it was Everett Carlson's truck because of the location of a patch on the fender, which I believe Carlson's truck had one on the rear passenger side, and the witness believed this one had a patch on the front driver's side. So that was the extent of information about the truck seen that night.
And when she went into the truck alone, did you go into the passenger side or the driver's side?
The witness did not say which side of the truck she entered.
So the closing.
Yes.
Do you think it's proper to characterize the defense evidence as not even worthy of the name evidence and all that kind of atmosphere?
I think that if you look at the entire closing together and in context, it's clear that the thrust of the whole argument was that the defense was weak. It was an attempt to distract you. It was an attempt to divert your attention away from the strong evidence of the defendant's guilt. And this court has said that that is proper. The prosecutor is allowed to comment on the weakness of the defense. The court has even approved a prosecutor saying that the defense was an insult when it was pointing out that evidence of self-defense in that particular case was particularly weak.
There are limits, aren't there?
There are limits, and the only of the claims the defendant is pursuing here, the only thing to which he objected below was the prosecutor's suggestion that there was certain evidence that should not have been before you. As to that claim, the judge gave a very, very strong, forceful, targeted instruction saying,
Well, he objected to 2 things.
but one of them he's not raising here. So of the claims he's pursuing here, he only objected to that one thing. So the judge essentially said, I don't usually do this, but this is so bad that I need to correct it. And I am telling you, he has suggested to you that this is not evidence, but I ruled on this, and this is evidence, and you will consider it.
But the well may have been poisoned.
Well, Your Honor, the court has said that, A, we presume that jurors heed these instructions, and B, that jurors recognize that argument is argument. And so to the extent there's some rhetoric or hyperbole, the court trusts that the jury can sort that out. If you put those things together with this very strong, targeted, curative instruction, I don't believe that this was the type of error that simply could not be cured.
Go ahead.
Well, it's that it immediately succeeded this appeal to, I represent the citizens of the Commonwealth, like you, and we are here with this very guilty man, and it just struck me as completely inappropriate at best.
Yeah, that comment, Your Honor, there was no objection to that.
Well, I don't care. I'm just saying it.
Yes, I understand. But again, I think that if you read the argument as a whole instead of parsing out specific parts of it, the jury would understand that the thrust of the argument was that this was a weak defense. He is trying to distract you away from the evidence of his own guilt. Each time that he says one of these things to which the defendant is now objecting, he explicitly says, because look at the evidence. There are no links connecting James Weber to this crime. There are no links connecting Everett Carlson to the crime. And he goes through the evidence about how they were excluded as sources of any of this DNA. Their trucks were both checked, and Weber's had no blood in it, and Carlson's, the only blood was his own. And Carlson was at the OUI class, and he specifically references the evidence. He doesn't just make a representation that, hey, I think this is weak and you shouldn't have heard it. He tells them why. So when you take all those remarks out of context, I understand that it may look inappropriate.
Of course, the danger is that if the evidence of defense is weak, that whatever life they may have had will be squelched by comments like this. I mean, those are precisely the circumstances under which this kind of an argument shouldn't be made. It shouldn't be made in the first place, but it's particularly harmful to a weak defense.
Well, but Your Honor, the court has recognized that the Commonwealth is allowed to marshal its evidence and show not only why its own evidence is strong, but why the defendant's evidence is weak. That's part of closing argument. That's part of litigating a case.
Yeah, but
no one.
There are ways of doing it, and there are ways that it shouldn't be done. Here, the prosecutor was even vouching, using his own confidence in the evidence to essentially, demean the defense.
But what he said in that remark, where he said he has a high degree of confidence, was again tied to the weakness of the defense. He said a high degree of confidence that the defendant has presented this evidence to you to distract you and divert your attention away from the evidence of his own guilt. So again, he wasn't just saying, I am highly confident that the defendant is guilty. He didn't vouch in the sense that what this court has called vouching, where somebody says, I've tried 1,000 cases and I can tell you from my own experience that this is the strongest one.
The rules are pretty clear, aren't they? What prosecutors can do and what they can't do. At some point, you get the impression that they're testing the court to see how much the court will put up with. And this is one of those cases that absolutely goes right up to the line, if not over the line. I mean, I'm going to suggest to you that maybe the admonitions that we've been giving have not been strong enough. And maybe you get exhausted trying to talk to prosecutors about what they should do and what they shouldn't do. But maybe we shouldn't rely on you to do that. We should have a ruling in one of these cases that makes it very clear that this won't be tolerated.
Well, Your Honor, I think the rules are clear.
Right.
And I understand here.
Do it anyway.
And I understand, there's no question this was a passionate argument. This was a very hard-fought case. There's no question this third-party culprit evidence was disputed from the beginning to the end. But to the extent that the prosecutor may have stepped over the line in making these remarks, again, the remarks that the defendant is challenging here are specifically those to which the trial judge directed this curative instruction. If there's a concern that the prosecutor was trying to test the judge and how far he could go, the judge said, whoa, you went too far. And he let the jury know that. It's not even that he just told the prosecutor at sidebar, hey, you went too far. He said to the jury, I don't normally do this, but this was so bad that I'm going to do it here. I don't think he could have been any stronger in telling the jury that was inappropriate and you are not going to consider what he said. And I ruled that that is evidence and you will consider that evidence. I mean, it's even, he explicitly told the jury, you must consider that evidence. So even if the jury had thought, wow, that evidence was really weak and I don't think we should even give it any consideration, the judge explicitly instructed them to consider it.
Yeah,
so,
but the judge is constrained to comment on, make the kind of comment that I just made about impropriety. I mean, he couldn't really address the prosecutor's tone, and he couldn't really go into the kind of detail that we're talking about here about everything that was wrong with what he did.
well, Your Honor, this is the only thing that the defendant objected to. And I think that also is a sign this court has recognized that when experienced defense counsel objects to one thing but not 5 others that he's now raising on appeal, that that's a suggestion that in the context of the trial and in the argument as a whole, it was not seen by defense counsel as being prejudicial.
But I mean, twice he says it's not supposed to divert your attention from the defendant who is on trial. That's the case whenever there's third-party culprit.
Yes, Your Honor. However, again, the court has recognized in several cases that I cite in my brief that it's an appropriate argument to say the defense evidence is weak.
Well, I understand that. It's perfectly appropriate to say what you said, which is let's look at their evidence of third-party culprit. But to say that it's essentially improper for the defendant to divert your attention from the defendant who is on trial, that is telling them it is improper to offer third-party culprit because that, by its very nature, diverts your attention from the defendant who is on trial. I mean, that's the real core problem. It basically is saying it's inappropriate for the defendant to offer third-party culprit evidence.
And the judge did not give the requested third-party culprit instruction, which, as I understand, not ordinarily required, but that might have been, that might have actually gone to cure this.
I actually don't believe there was anything in the third-party culprit instruction that he requested that would have really gone to this any more than the curative instruction did. The instruction that he requested essentially told the jury, you shall consider this evidence about whether someone else did it. And that's really what the curative instruction did anyway. And as I argue in my brief, I think his proposed instruction had other problems, including shifting the burden of proof to the defendant. So had the judge given it, I think we would have been here on an additional claim.
Do you know if there is a tape still extant? One could hear this as opposed, in addition to just reading it?
The closing argument, I would assume that there is, and I could try to provide that to the court if you would like it.
All right, thank you.
Thank you.